I wanted to start with you, Ms. Hill. I appreciate the references you made to federalism in the reservations that the United States has advocated. Can you talk to me for a minute about how those reservations are upheld, how they remain intact, whether or to what extent they're honored, and what impact they would have on a court's interpretation of the treaty were it to be ratified?
I don't know of courts that have rejected RUDs, and the most important one is the self-executing declaration, and that has been upheld. So I don't know of any courts that have rejected a RUD and then expanded their jurisdiction to be able to enforce anything contrary to a RUD that was adopted through this process.
Harold Coe has been at times critical of what he sometimes describes as Swiss cheese ratification, where he says there was a 2003 Stanford Law Review article in which he wrote that ratification of multilateral treaties with so many reservations, understandings, and declarations that these conditions substantially limit the U.S. acceptance of these treaties. Do you share that concern that we sometimes tread into that zone and create a Swiss cheese ratification? And if so, are we approaching that here?
I don't believe so. We've recommended 3 reservations, 5 understandings, and 1 declaration, which I don't think in any way make this a Swiss cheese approach to the treaty. That this is adopting the treaty and identifying the ways that it applies to our system.
Okay. Some have expressed concerns about Article 7 of the Convention, which I'm told is patterned somewhat, or contains language patterned somewhat after corresponding language in the UN Convention on the Rights of the Child. And this language, according to some of the critics, focuses on the best interests of the child standard. That's a familiar standard to us in some respects here in the United States, in that that's a standard that is frequently employed by courts in making custody determinations in the context of a divorce, and in those rare cases involving the invalidation of parental rights with an abusive home environment. It's sometimes a standard that is used to decide where the child goes then if the parental rights are dissolved. Mm-hmm. But the critics would say that Article 7 of this convention would inject the best interests of the child standard into other contexts, so contexts in which parents currently enjoy certain rights, certain the right to make certain decisions unencumbered by the decisions of the state. Can you comment on those?
To the extent that that's the concern, that this would reach into the private home and the private decisions of parents about how to raise their children, that would be protected by the private action reservation. So that would keep the UN Convention, anything that might be read to interfere with that would be protected. The private action would be protected by the private action reservation.
Meaning that because no one has a private right of action to enforce the terms of the convention itself, that would take care of this concern?
No, this would be that we interpret the ability of the application of the UN Convention to respect the distinctions between what we as a federal government can regulate in terms of private action and what we cannot. And so in these cases, the home and family determinations of parents, unless they reach a level of state law, are within private action and would not be regulated under the convention. If they do reach a level of state law, and state law has most jurisdiction over things like neglect and so forth, then you would get into the federalism reservation that would also say that state law would continue to apply in the way that it currently does.
Okay. So the reservation, as you understand it, particularly the federalism reservation, makes sure that we don't have a creep of federal law into areas currently covered by state law, which would include most custody determinations, most determinations regarding eligibility for educational programs and things like that. Is that correct?
Correct. Things that are beyond the Congress's power to regulate now.
Okay. There are some critics who have pointed to provisions of the IDEA and pointed out that parents have certain rights under the IDEA, and that aspect of federal law would be modified by Article 7 of the convention, of this convention. Can you comment on that?
Those are interpreted through our non-discrimination understanding, that those would be read as non-discrimination obligations rather than as any affirmative obligations, and would not inhibit parents' ability to both participate in the IEP process and make their positions known, and to make their decisions to reject special education services that were being proposed by a school.
So you would agree that without those reservations, that might be a change to existing law. It might be a change to the existing law under the IDEA, but with reservations, there's not a change.
I actually don't believe, I was accepting for the purposes of the argument that that would be the case, but I actually don't believe that this changes the basic approach of the IDEA, which already includes the best interest of the child and already includes the participation of the child as appropriate in the decision making. Okay.
There's a Professor, Geraldine Van Buren, who apparently assisted in the drafting of the corresponding language in the Convention on the Rights of the Child, who, in reference to the corresponding language in the Convention on the Rights of the Child, said that the best interest standard provides decision and policymakers with the authority to substitute their own decisions for either the child's or the parents', providing it is based on considerations of the best interests of the child. Do you agree? Do you disagree with Professor Van Buren?
She's talking about the Convention on the Rights of Children, and I am not an expert in the Convention on the Rights of Children, but the difference, at least one of the differences between that convention and this one, is that this is a non-discrimination convention. So this does not add laws, add benefits, add requirements regarding individuals with disabilities that are not equal and the same as those added for children without disabilities. So if we had adopted the CRC, then those rights would carry on to children with disabilities, but not having pursued that, the rights provided to children with disabilities under this would be non-discrimination rights.
So the different context in which similar language was used in the CRC gives it a different application there than it would have here, since this is in the context of non-discrimination.
Correct, and then re-emphasized by our interpretation of all economic, social, and cultural rights as non-discrimination rights.